the state of Florida. Counsel for the appellant, you may proceed when you're ready.
Thank you, Your Honor, and may it please the court, I'm Phil Padovano, counsel for the appellant, Denise Williams. With me at counsel table is Ethan Way, who served as trial counsel in this case. I'd like to reserve 4 minutes for rebuttal. In the time that we have together today, I hope to discuss with you the sufficiency of the evidence to convict Ms. Williams as a principal to the murder committed by Brian Winchester. And also, time permitting, the trial judge's decision to send to the jury the principal and the accessory charge at the same time with the option of convicting her of both of those. We believe that was an error, and I hope I'll have a minute or two to explain to you why. Let me begin with the applicable test for principal. The Supreme Court said in the leading case of Staten versus State, in order to be guilty as a principal for a crime physically committed by another, one must intend that the crime be committed and do some act to assist the other person in actually committing the crime. So to frame the issue, what we're talking about here, what the Supreme Court is talking about here, is not what is needed to plan a crime, not what is needed to cover up a crime. Those are different offenses. But what is needed to prove that somebody was a principal to a crime.
Now, in that case, though, wasn't that language dicta by the Florida Supreme Court?
I believe it was dicta in that case, but I don't believe it's dicta in your case of Ammons v. State, which followed that case, because in Ammons v. State, you may recall it was an opinion written by Judge Thomas, then Chief Judge Thomas, who said that the evidence, he cited the rule in Staten, just the way I did, and he actually emphasized the words, commit some act. He actually, that was his emphasis.
Right.
Wasn't
the
emphasis
difficulty with that case is we don't have any facts to frame the issue. So we don't know if the issue was whether it was a verbal act that was sufficient or if it needed to be some sort of physical act.
We don't, but what we do know is that Judge Thomas said that the evidence was sufficient to show that the defendant in that case had an intent to that the crime be committed, but that there was no act. He actually said there was no act. That was the reason the court reversed the case.
Well, assuming we agree with you that that's part of the holding of Ammons, is that in conflict with the plain language of the principal statute? Is there anything in the statute that requires a specific act?
That's a good question. Thank you for asking, and I think it's something the court should consider. The statute does say, let me see if I can get the exact language, counsels. It uses the word counsels. And I have said in our brief that we concede that the statute is more broadly worded than the rule as stated in Staten. But here's the thing. The Supreme Court had the benefit of that statute. The Supreme Court quoted that statute in full in the Staten opinion. So they've interpreted it. They weren't unaware of the statute. And by the way, at the time of Staten, the statute was verbatim the same as it is now. And so the court has interpreted it to require an act, not only an act, but an act in the assisting in the actual commission of the crime. I take your point about the wording of the statute. I think that's an interesting question if the court were to certainly to disagree with the way the Supreme Court has interpreted. There's a procedure for that.
Well, I think we resolved that the Supreme Court's language was dicta in that particular case. And it does seem to me that the plain language of the statute is consistent with the standard jury instruction. So could you address that point? I mean, how is the jury instruction inconsistent with the text of the statute?
I don't believe that it is, but I think it is inconsistent with every holding on this of every case on this issue. We have said in our brief that there has never been a case in Florida where somebody was convicted as a principal based on a verbal act. First of all, verbal act is kind of an oxymoron, but there's never been a case. Now, I didn't outline all of the cases in Florida, but what I did do in the brief is I outlined all of the First District Court of Appeal cases. Every single one of those cases involves an act. And that is consistent with our common understanding of what a principal is. It's somebody who drives a getaway car, somebody who serves as a lookout, somebody who offers a gun.
Or someone who, over the phone, directs individuals where to go in a house to commit a crime.
Yes, and I think that's an act. I mean, I think he was, in that case that they cited, that man was standing outside at the scene of a crime. He was conducting the actual crime on the phone in a 39-minute telephone call. So I think that is an act. Yes, he spoke words.
So can you focus on, the theme in these questions is, and you indicate verbal act is an oxymoron in a way, or it's like red-green.
Right.
What is an act to you, or make the distinction between something that's verbal and something that's an act?
Well, I think something that you say is verbal, and I guess there are. I mean, I said that not too facetiously. There are some things as verbal acts. I think child abuse cases. We could have a situation where the crime itself involves a statement, let's say perjury. Obviously, you can't commit perjury without speaking a lie. And so it seems like you could have it in that situation. But for most crimes, you remember, require an actus reus and a mens rea.
Okay, well, let's go back to the statutory language. In addition to the word counsel, it also includes the word abets. What is the plain and ordinary meaning of that term? Abets.
I'm sorry, which word? I'm sorry, Judge.
Aids or abets, counsels, hires, or otherwise procures such offense. So what does it mean to abet?
I think aids and abets, the common understanding of that is somebody who assists in the commission of the crime. You remember that the principal statute is one that evolved from the previous aiding and abetting statutes.
And from the common law, correct?
And from the common law. And that throughout history has required some form of assistance. But before you leave that point, it also means an accessory before the fact. So let's to give you a hypothetical, in terms of the plain language of this statute, abetting and procures. If a person were to say, I want you to go shoot the person outside this courtroom right now, and I'll pay you later, all right? And the second person goes and pulls the trigger. Is that person not aiding or abetting within the plain meaning of the statute? Yes, but I think that's different because the paying, first of all, comes in within the hiring in the statute, and the paying is an act. So let me make a point about this that I think is, I don't believe that there's any case in Florida where a verbal act was ever found to be sufficient. And if you think that maybe because of the jury instruction and the statute, that should be the case, I don't think this is the case to make that point, because the statute requires, the statute says, otherwise procures. Now that carries with it some sense of causation. That you didn't just say something, I think it would be a nice idea to kill John. You actually caused it to happen. So if you had a situation, let's say, where the perpetrator was standing over the victim with a gun, but he chickened out, and the alleged principal was at the scene, and he gave him moral courage by saying, do it now. Now you've got something, and I'm not conceding that a verbal act is ever enough, but now you at least have a situation where there is some verbalization that helps to cause the crime. It's at the scene, and it actually helps. Remember, the Supreme Court said, in the actual commission of the crime.
Well, let me ask, I think the state argued in its briefs that Denise's part of the plan was to make sure he showed up for the duck hunting trip. Why is that not an act, or at a minimum, the verbalization of an act? It
would be an act if there was any evidence that it happened, but there is no evidence that it happened. So let's look at what Brian said. Denise's role. He said, Denise really didn't have to do a whole lot other than come up with an alibi for herself and make sure Mike went. Well, first of all, I don't know why it would be necessary to come up with an alibi if she wasn't going anywhere, she was staying home. But there's no evidence that she came up with an alibi for herself, and there is no evidence whatsoever that she ensured that he go hunting that day. The idea was the trip on December 16th was planned between Brian and Mike exclusively. So that is not an act. I mean, it would have been an act. I think it would have been an act, but there's no evidence of it.
But
Sorry, go ahead.
didn't the evidence also show that December 16th was a date that the victim planned to take his wife out for an anniversary date, correct?
Right.
Right, and so there was evidence that that plan changed, and it changed, that was based on testimony by Mr. Winchester, correct?
The plan changed?
The plan to go out to Apalachicola the evening of December 16th.
That plan, I don't believe, changed. The first trip was December 9th, and that one didn't come off. But is that what you're referring to?
No, I'm referring to the fact that the victim and the defendant had plans to go
Oh,
out the
yes.
evening of the
Yes.
16th. So
Yes.
certainly, there's some testimony by Mr. Winchester to make sure that he went duck hunting that same day that they planned to go out of town, correct?
That's right.
Right, why was that not legally sufficient to go to the jury?
Well, first of all, the duck hunting was at 4 in the morning or something. They got back before normal people even get up. They weren't going to Apalachicola until later that afternoon. It takes 90 minutes to drive there. So I don't think there was any question. I mean, I guess maybe you could say, well, they were going to Apalachicola, ergo Denise must have given him permission, ergo that is somehow assisting in him going hunting. But respectfully, I think that's stacking a lot of inferences on top of a lot of inferences. She didn't do anything. He planned that trip. He planned that entire trip on his own. We don't know what she did. We don't know if she objected and he went anyway. We don't know what, if anything, she said to him. We don't even know if she was awake when. So, I mean, I think you'd have to do a whole bunch of inferences to get to that point. I know I'm into my rebuttal time. Let me just briefly mention this other point because I think it's very important. We have Florida Supreme Court cases that say this is a reversible error. I don't see how the state gets around this. I mean, they didn't, by the way. They didn't even address it in the
compelling
brief.
election?
Yes,
The
I'm sorry.
compelling election point.
I'm sorry. The motion to compel an election, yes. We know that principal and accessory are inconsistent with one another. They're mutually exclusive. We know that. We know that from a series of Supreme Court cases that we cited, that if you have mutually inconsistent cases, the defendant has a right to compel an election between those and not to be forced to go to trial for both at the same time if you make a timely motion.
We also have a host of cases where the crimes at issue in this case were at issue, and the remedy was simply to vacate one
That's
of the
correct.
convictions. And
That's
I understand in those cases there wasn't a discussion about motions to compel, but why is there a difference? Well, the prejudice is the same.
Respectfully, I don't think it is the same because there was no motion to compel in those cases. The argument was made in all those cases for the first time on appeal, and the court has no choice but to vacate one of those because the convictions are inconsistent with one another. But the Supreme Court has said that if you make a timely motion to compel an election at the close of the evidence presented by the state, you have a right to that, and if the charges are mutually exclusive, that the failure to do it is reversible error.
Well,
And
I
I've
guess
cited-
my question is, how is the prejudice to the defendant any different in the cases where a motion is filed and in the case where one is not?
If you're going to say that just vacating this, if you're going to say that vacating the conviction is enough, after all, no harm, no foul, you vacated it, what would the point be of having a motion to compel an election? There would be no point in it. You would be basically saying the Florida Supreme Court says a defendant has this right, but it doesn't really mean anything because the state can load up a bunch of charges, send it to the jury, let the jury do like a smorgasbord, pick the one they want, and then the state can come back in and say later, oh, well, I'm going to vacate this one. By the way, the least serious one. I don't know why they have the right to do that. I asked them to make an election when the case went to the jury. It seems to me they forfeited the right to elect which one it would be afterwards.
Yeah,
But no, they were.
Mr. Padovano,
I
I'm going
don't-
to give you some more time.
I will
because
appreciate
these are-
that, and
These are important questions,
Yes.
and I know I have another question, and my colleagues
Okay.
may as well. But on this issue, I thought it was interesting. The Florida Supreme Court cases you rely on are dated from the 40s, and there's
They are.
very few cases cited after that, and I'm curious to know what the reason is. You would think that if this really is a general principle that's transferable to principal and accessory after the fact, it would have come up before now.
Well, I'm going to tell you what an appellate judge lawyer should probably never say. I don't know the answer to that question. But what I do know is I think you have to follow Supreme Court precedent no matter how old it is. And I will say that respectfully. I believe that's the case. I looked at all these cases. They don't have any red flags on them. They've never been overruled. And the state has not even explained why they don't apply. They say, well, they dealt with theft. But there's nothing in those cases that limits that to theft. And I will also say that there are some cases in the 70s, one from this court and one from the 5th DCA that we cited, or 4th, I think, where the court reversed for a new trial on all charges, even the charges that weren't affected by the mutual exclusivity. So I think that the rule is that it's reversible error.
Okay.
And
I'm going to extend your time just a little bit
Okay.
more. Go
Thank you,
ahead.
Chief. Switching gears, your argument about the prosecutor's comment in the closing argument, obviously you're asserting it's fundamental error.
Yes.
That's your position because it wasn't preserved. How do you I'm having a hard time understanding how you distinguish Pope and how the facts in that case was not fundamental error, but here it would be fundamental error.
I think
in that case, that was where the prosecutor made a comment about, look at the defendant sitting there grinning ear to ear. Why do you think that those kinds of comments, and the court concluded it wasn't fundamental error? Or you don't have to dig around and if you want to just explain why this particular case screams fundamental error, why it goes to the heart of the trial.
I think it was the manner in which it was done, and actually what was done, especially following some of the other things that were done. To sit there and say that she was, cold and showed no emotion when everybody else in the room was crying. It was not just I don't think it was the same as the offhanded thing of, I think in Pope, the defendant was grinning when his girlfriend testified or something, and the court thought it was relatively insignificant. We did cite a New Jersey case where they found it was fundamental error, and I think it's very similar. The bottom line is that's not, that is a decision for you to make. That test is very subjective. I concede that. But I think it was a particularly egregious thing to do.
But is your point here, are you tying it to the idea that it undercuts the Fifth and Sixth Amendment
Yes,
rights?
absolutely.
Is that your argument on that?
Absolutely, Your Honor, absolutely. The Ninth Circuit opinion in Schuler said that it allows improper character evidence when character is not an issue, and it also indirectly violates the privilege against self-incrimination, because you're basically saying to her, okay, defend yourself, against that. And a defendant shouldn't have to do that.
Well,
So-
in the Sims case, though, the Florida Supreme Court heralded that a jury's improper consideration of defendant's election not to testify was not this extraneous evidence type issue that I think you're contending happened here.
Yeah, well, if you're talking about like the effect of this on the jury,
Right.
Well, I think the difference is in the Devaney case, they try to draw a bright line of things that were inherent in the verdict, things that were, if a jury makes a mistake, for example, if a jury doesn't follow an instruction, if a jury misunderstands evidence, if a jury says that they considered a defendant's failure to testify even when they were told not to, that inheres in the verdict. But it's very different from a situation where the jury actually is exposed to outside influences. For example, somebody says, well, I know he's guilty because my brother-in-law knows him and he knows all about it. Or even cases where people bring a dictionary into the jury room. It's an outside influence. So the distinction, I think it's an important distinction, is was the jury exposed to something improper, or did the jury make a mistake? The jury mistake is off limits. We're not arguing that. Judge Hankinson made a mistake in saying that this inhered in the verdict. It did not, because it was objective material that the jury should not have been exposed to, something that wasn't in evidence.
Okay.
Well, I suppose I owe you an apology here. I'm way
No,
over.
we took most of your time, so Madam Clerk, if you would please extend his time for 4 minutes for rebuttal. Of course, give the state that time plus whatever we went over. Thank you, and I apologize for that.
Good afternoon, and may it please the court. I'm Ben Hoffman from the Attorney General's Office, and I represent the state. And I'm going to go a little bit out of order with those issues, and I'm going to start actually with the motion to compel an election, because I think I could actually clear that one up really quickly. So I can't remember if it was you, Judge Rowe, or Judge Ray, had asked a question about, well, Pierce and Mayers and these other cases that say it's per se reversible error to deny a timely motion to compel an election, and why is it that no case has cited to them, or no recent case has cited to them. I think the simple answer is those cases predate DeGilio, the Florida Supreme Court's case of DeGilio. It predates the modern harmless error statute. And we know that over the years, the Florida Supreme Court has increasingly moved away from this per se reversible error standard. So when you're talking about cases like Pierce and Mayers and I think Johnson was in the 1970s, all of those predate DeGilio, which is 1986. So I would say that this court has an obligation to follow DeGilio, and it's interesting that the defense actually relies not on the per se reversible part, but they rely in part on Bazemore out of the 2nd District. And Bazemore is interesting because it's the only case they cite that comes after DeGilio. It's a 2011 decision, and Bazemore actually applies the harmless error test. Now, in that case, they found the error wasn't harmless for reasons that really aren't applicable to our case. For instance, there, the verdict forms did not have the victims' names. And the fear that, or I guess the prejudice that the 2nd District in Bazemore addressed was, if you were to try to go back and force the jury to choose between accessory after the fact or principal, we don't know what they would pick. This case is different because the evidence that gave rise to her principal conviction and the evidence that gave rise to the accessory conviction are different. They're not related. They're not in the same decade. It's 16 years apart. So there's no danger, for instance, if you were to go back and put the evidence of the defendant's principal conduct in front of the jury, there's no danger that they would pick accessory based on that evidence. And likewise, if you were to put the accessory evidence in front of the jury and ask them to choose, there's no danger that they're going to pick principal because it's completely different evidence.
But isn't the point where the crime starts is different in the two, and you're essentially you're having the jury unanimously conclude two different crimes with mutually exclusive mens rea, and really when the offense starts, you're having them unanimously conclude mutually exclusive facts. Isn't that the error or the harm that the rule, at least originally, was intended to?
I agree that the rule, I think, is based on the idea. So for instance, Statton is the typical case of the getaway driver, and I think Bazemore was also the getaway driver. So I don't agree with you, Judge Tannenbaum, to the extent that these are factually incompatible. I agree when you have a getaway driver case. So for instance, Statton and Bazemore, when the accessory conduct and the principal conduct is based on driving, and there's this question of did you form this intent at the same time or really close in time within a matter of seconds, I agree that's a factual incompatibility. And I think it was, for instance, in the Johnson case from the 70s where it was either Johnson actually or it may have been Pierce, but one of them, the state charged him as the thief in the fence. And I think there was a line from one of those decisions that basically, I'm paraphrasing, says you can't be a thief and a fence at the same time. So when you're a getaway driver, you can't be a principal and an accessory at the same time. That's the general idea. So to the extent that it's based on that, I agree those are factually incompatible. But when the conduct in question for the accessory is 16 years after the conduct in question for the principal, I don't agree that those are factually incompatible. So again, going back to, I guess, the danger, if we were to go back, Bazemore addresses it a harmless error standard. If we were to go back and tell the jury, based on the evidence presented to you, pick one or the other, there's no danger that they're going to look at the principal evidence and pick accessory, and there's no danger that they're going to look at the accessory evidence and pick principal, and that's what Bazemore was getting at under the harmless error test.
But the accessory after the fact would assume, so taking the 16-year delay in her involvement, that isn't that saying she chose to assist in the crime 16 years after the fact, and at the same time the jury is supposed to conclude, or the state is asking the jury to conclude unanimously that she was actually part of the crime 16 years earlier, that she's then 16 years later first deciding to help with.
Right. I think, if I understand your question, so she forms the intent to be a principal,
Right.
really, I guess, all throughout 2000.
Well, she doesn't form an
finishes-
intent to be in principle. Under principle theory, she's part of the crime. She's committing the crime
Well, right, but
as if she was doing it.
sure, and so she's a principal as soon as the murder's committed.
Right.
So once the murder's committed, 16 years go by, and she then forms the intent, knowing that Brian Winchester has committed this murder while she's being interviewed by law enforcement.
But
and they
she's
ask-
both doing the crime. I mean, she's part of the crime too, because she's a principal.
Right, and what I'm getting is we've never had a case like that where there's that big of a gap in time. It's always been the getaway driver, or for instance, this court's actually decided the Page Vowell case, and Chief Judge Ray, I think you wrote that opinion. But in Page Vowell, she lured the victim to his death, and then immediately after his death, she helped clean up and try to dispose of the body. So again, she formed the intent at the same time, and I agree that it's factually incompatible for her to be a principal and an accessory based on luring a victim there and then immediately helping to cover it up. But I think the 16-year gap is something Florida courts have never addressed, and I'm not so sure that in Staten, the Florida Supreme Court would have come out the way it did if we were dealing with facts like this. And even in Staten, there's a case that the Florida Supreme Court cites in Staten out of California, and I don't have it offhand, but it's the only California case they cite. And they cite it with approval, and that case actually noted that there are exceptions, or there can be exceptions to this idea that you can't be an accessory and a principal to the same crime in, quote, exceptional factual circumstances. And I would say that this is an exceptional factual circumstance, even though I would agree that as the law stands now, they're legally incompatible, and that's why I think it was right to dismiss the accessory after the fact charge. But the larger point, though, is when the defense says it's per se reversible error to send both charges to the jury, I disagree. And all of that case law predates DeGilio. It predates the modern harmless error statute, and this court does have an obligation to follow DeGilio.
Well, but could you cite us to any case where a motion to compel an election was filed and the remedy was something other than granting a new trial?
No, other than in Bazemore, the second district specifically, so it found it was not a harmless error, but the second district specifically said that there are times when the appropriate remedy in such a circumstance would be to vacate the lesser of the two. And it just turned out that in that case, that not on those facts, that wasn't the case. This is a completely different case. And again, it's because the evidence of each charge was separate from one another. I want to move on to the sufficiency of the evidence. And I think I can confidently start and end the analysis with the statute. So we all know it's the legislature's function to define crimes. And the legislature has defined a principal as obviously the person who commits the offense, and also as somebody who aids, abets, counsels, hires, or otherwise procures the commission of that offense. Now, it uses words like counsel, otherwise procure. I don't know how you can physically counsel someone to commit a crime. I don't know of any case that limits otherwise procures to physically procuring. Typically, when we procure something, it's verbal.
And what's the plain meaning of the word abet?
Well, I guess to quote Mr. Padovano, I hate to say it, but I don't know. To be completely
Well,
candid with you.
I can give you at least one dictionary meaning is to encourage another. And the statute also, in addition to using aids, abets, points to that it doesn't matter if the defendant is actually or constructively present at the commission of the crime. So how does someone abet when they are not present at the scene of the crime?
Well, I don't remember which case it was, but the case where he's on the phone directing, I think you have the three people that commit the home invasion robbery, and then the fourth co-defendant's on the phone directing them. I don't think you're not physically there, but you're encouraging, you're counseling, I guess you would be abetting them in that circumstance. And I don't agree that there's never been a case that has upheld a principal conviction based on words alone, and I'll go back to Vowell. Page Vowell is a perfect example. Now, it's not apparent from the opinion because the court was dealing with the accessory and principal charges, but Page Vowell lured the victim to his death, and there was some question about whether she called him or texted him, but there was no question that through words, she lured him to his death, and that was the basis that she was a principal.
Okay,
So-
well then let's go to the facts of this case and the evidence that's in the record. What are the words in the record that lured him to his death?
Well, I don't know if well, so getting to, I guess, counsel's point about, I know you had asked a question about this defendant's role in the case was in part to get Mike to show up on this hunting trip. And there's, I guess, talk of, there's no evidence of what she actually said to him, but remember that on a judgment of acquittal standard, the state is entitled to all reasonable inferences that the jury could draw from the evidence. So with that in mind, the way Brian Winchester described the plan is that this defendant has to ensure that he shows up, and he specifically said, I wanted to make sure that Mike showed up to the trip. We know that the week before the actual murder, she unilaterally delayed the plan, so she's got enough control over whether the victim's going to show up that she actually can cancel it and tell him, no, I don't want you to go. And then the next week, he shows up after Brian Winchester said, it's the same plan, it's the same night, just a week later. So I think from that evidence, you can infer that if it's the same plan, her role is the same. If she had previously unilaterally canceled this, and keeping in mind that now we're on their anniversary, they have a trip planned to go to Apalachicola, I think the jury could make a reasonable inference that there is no way he showed up for that trip without talking to her first.
And the evidence showed that the victim, who was the victim going to be going duck hunting with?
Brian Winchester.
Right, and Mr. Winchester testified that Ms. Williams knew that he was going to be hunting with the victim, correct?
Correct.
And so when Mr. Williams didn't return home, did the victim ever call Mr. Winchester that day?
Well, no, she never called Winchester. I think she did call around, but
The person that he was purportedly duck hunting with that very morning.
correct. So she never calls Brian Winchester, and I think at one point when she's asked by law enforcement, she even says, "Well, go talk to Brian. He was hunting with Brian." So I mean, she clearly knew where he was, and I think the jury could make the inference based on Brian Winchester's testimony that there is no way Mike Williams showed up on that duck hunting trip without speaking to this defendant and getting her approval.
Well, how do you get to that point? Because I get the evidence shows, or the testimony shows, 1 week it's canceled because she tells the victim not to go. The next week, it could easily follow that she just didn't say anything to him about not going that next week. So is the state's position then that the verbal act, so to speak, was her failure to tell him not to go on that day to the hunting trip, knowing that he was going to go and get murdered?
Well, no, my argument is there's a fair inference from the record that the victim had a conversation with her, and that he either got her tacit approval, or not tacit, I guess, her explicit approval, or she gave him permission to go. But I mean, it's their anniversary, and they have a trip planned.
And
There is
wasn't
no
there
way
also-
they didn't have a conversation.
Wasn't there also testimony by Mr. Winchester that there were numerous conversations between December 9th and 16th between the defendant and Mr. Winchester regarding firming up plans for the murder to occur on the 16th?
That's correct, Your Honor.
And he did, in fact, show up on the 16th to go duck hunting.
He did, and he said the plan was the same, so presumably this defendant's involvement is the same if it's the same plan, which is make sure he shows up.
So coming back then to the first question, which is, so what is it? What were the words, or what did Ms. Williams say to, if it's not based on an act, it's based on words, what is it that she did or said?
I can't quote Miss Williams because, it's not in the record exactly what her words are.
Well, what did Mr. Winchester say that she said to get Mr. Williams to go on this hunting trip? Or otherwise, what did Mr. Winchester testify to that Ms. Williams said to assist this offense to happen?
What he said was they agreed on a specific plan, that her involvement, other than alibis, was to make sure that he went, that they reaffirmed that agreement after she canceled the first time, which presumably means her involvement is the same, and then he shows up on the day in question, the day of the murder, and that later when this defendant's questioned by law enforcement, she says to the effect of, well, go talk to Brian, he was hunting with Brian.
Just for purposes of my question, assuming that we disagree with you on that point, is there any other evidence in the record that she verbally acted or physically acted in some way to facilitate the crime?
Yes, and that actually was not my primary argument of what her
Okay.
physical act was. So in my brief, my first argument was actually that so Brian Winchester testified about the life insurance policies and how first he's got a $250,000 policy, a $500,000 policy, and shortly before his death, he gets $1 million life insurance policy. And Winchester describes this conversation he has with the victim where the victim makes clear that he wants the $500,000 policy to lapse. He wants the $1 million policy to replace it. And he uses these exact words that I'm about to say. Behind his back, she paid the $500,000 premium to keep it open, which extended the window of opportunity to kill him under the motive of she wants the life insurance money. Her writing a check, that's a physical act. She wrote a check without him knowing about it to keep that policy open. And Winchester was very specific in saying that not only was it behind his back, but he was worried that they could only get away with doing it once before the victim found out what they were doing. So that was actually my first argument for what the physical act was.
And when did the defendant first make a claim on that policy?
19 days after, I think it was January 4th, 2001. So 19 days after the victim's disappearance.
And was that a time when people were still searching for the victim?
Yes, it was.
So wouldn't that act, though, wouldn't that matter more if this were an insurance fraud case as opposed to a murder case? I mean, the fact that she wrote a check for a premium, that indicates the intent part of aiding and abetting.
Well,
How does the insurance policy premium facilitate the murder of Mr. Winchester?
because the state's theory of the case as to the defendant was that her motive was obviously she wanted to be with Brian Winchester. They're having this affair for years beforehand. She doesn't want a divorce because she doesn't want to share custody, or at least in part doesn't want to share custody. So that's part of the motive. And the other part of the motive was she wants the life insurance money. And Judge Tannenbaum, to I guess better illustrate that point, Brian Winchester also testified as to the $1 million life insurance policy that the victim got that policy, I think it was, according to Winchester, 6 months to a year before the murder occurred. And that he also said that him and this defendant started planning the murder, it was a year to a year and a half before the murder. So based on those timeframes that I just told you, this defendant was encouraging the victim to take out $1 million policy while she was simultaneously planning his murder. I guess illustrates the point that that's an act in furtherance of it.
An act in furtherance.
It's an
of
act
what?
in furtherance of wanting to murder him. It's an act.
Well, she's not charged and wasn't convicted of wanting to murder him.
Well,
she was convicted of being a principal to murder.
Right, but part of that is she has to intend for the murder to occur.
Sure.
And the defense is saying she has to commit an act in furtherance of the murder. And if her motive, in part, was the life insurance money, when she's writing checks behind the victim's back to keep the policy open, when she's encouraging the victim to take out more life insurance while she is simultaneously planning his demise, those are acts in furtherance of the murder.
That sounds more like an argument in favor of conspiracy to murder. If the conspiracy, the furtherance idea, if we don't have an overt act requirement in Florida for a conspiracy, and it sounds like you're merging on the principal charge, you're merging the intent and the actus reus, or the actual thing that she did to facilitate the crime.
Well, my larger position is that you don't need to commit an act at all under principal theory.
Sure. Or say,
say
something to encourage it. to
Right.
happen.
So we're talking about an alternative argument that even if you were to hold that an act is required, this would qualify as an act. And I guess to analogize, me and the defense, we disagreed on how we read this court's decision in Banks from 1991. So Banks was the case where the defendant was charged, I think it was sexual battery, and he procures witnesses to give him a false alibi. So on top of the sexual battery charge, the state then charges him with being a principal to the perjury. And the theory is he procured these witnesses to provide false alibis, and that when they went to their depositions, they actually did lie. And the disagreement comes from the fact that he not only procured them to lie, but he actually wrote out a script for them. And the way the defense is asserting that this court should read Banks is that he committed a physical act by writing out a script and then calling the witnesses and coaching them prior to their depositions. And if they're correct and that's an act, what I'm saying is this defendant writing a check is no different than the defendant in Banks writing out a script. So my first position is you don't need an act at all. But even if you need an act, her writing a check and paying this policy behind the victim's back is the physical act that would be in furtherance of the crime.
Well, could the murder have been committed but for the renewal of the life insurance?
I'm not quite sure.
In
I
other
understand.
words, that wasn't the renewal of the life insurance isn't causally related to the murder, is it? Or if
It's
it
not
is,
physically
explain to me how it
necessary.
is.
I'm sorry, I didn't mean to cut you off. It's
Yeah.
not physically necessary, but Brian and this is where the devil is in the details with Brian Winchester's testimony. He's talking about the window of opportunity, and there's two primary concerns going on with their window of opportunity. One is this has to occur during duck hunting season. Duck hunting season isn't very long, and even within duck hunting season, he explained, you can't just go any day you want. So one concern is duck hunting season. The other concern, and he was very specific, is they needed to do this before the policy lapsed. And that's where it comes into play that behind this victim's back, she paid to keep the $500,000 policy alive, which extends the window of opportunity that Brian Winchester was talking about. So while it's not physically a requirement to commit the murder, it's extending the window of opportunity that was a concern to them. So I guess in a way, it kind of, based on the motive, it kind of was necessary for one of their concerns. And then the final point I just want to briefly address is the closing argument. I did make an argument that it was invited. I stand by that, but for purposes of oral argument today, I want to address the fundamental error aspect of it. And it's not fundamental. First, all of the cases that the defense cites, none of them have found a comment on a defendant's off-the-stand demeanor to be fundamental. So for instance, someone talked about the Pope case where the defendants grinned from ear to ear. That wasn't found to be fundamental error. There's another case in which the prosecutor commented, so it's Rodriguez, where the prosecutor commented on the fact that the defendant was sleeping in front of the jury. That one was actually preserved and still not found to be reversible. The only one of the cases that the defense cites that actually resulted in a reversal was Baldez, where the prosecutor commented on the fact that the defendant was glaring at a witness. That was a preserved objection. So none of the cases they rely on have found such a comment to be fundamental. And in this case, it's not fundamental because this isn't the first time that the jury heard about this defendant's demeanor. So this was a 3-day trial, and throughout the course of the 3-day trial, the jury repeatedly heard about how this defendant's demeanor throughout this whole process was inappropriate for someone who's a grieving widow. Just very quickly, I picked out 4 examples of throughout this trial where the jury heard such evidence. So for instance, Cheryl and Nick Williams both testified to 2 encounters that they had with Miss Williams. And in both of those encounters, she was angry and she threatened Miss Williams and Mr. Williams that if they don't stop this investigation, they're not going to see their granddaughter or their niece again. And one of those is 5 months or 6 to 9 months after the disappearance. The other one is 5 years after the disappearance. Years later, there's then this recorded phone call with Kathy Thomas in which Ms. Thomas twice accuses this defendant of murder, and she doesn't react in anger, despite the fact that she's just been accused of murder twice. And in fact, when she's asked, why couldn't you all just get a divorce, she actually answers the question, very interestingly, and I would argue it's a tacit admission, but she answers the question and essentially says, I couldn't do anything with the divorce, was her answer. And then she starts talking about she would have had to get lawyers and all this stuff. So the bottom line is this is not the first time the jury was introduced to the idea that this defendant's demeanor was inappropriate.
But doesn't that point undercut your argument that this was invited error? What couldn't it have been that the defense counsel was commenting at closing about that aspect, that testimony about demeanor, as opposed to demeanor in court?
You're talking about her demeanor before trial?
Right.
No, well, if he had stopped, so I actually have the exact wording. If he had stopped at, it's not a case about how people mourn, it's not a case about how people grieve. If he had stopped right there, I would fully agree that he's referring to her out-of-court demeanor. But he then takes it farther and says, it's not a case about whether people sit there and stare. And that's clearly a reference to what's happening in the courtroom. And it was a strategic decision made because everybody knew the jury was staring at Miss Williams and knew that was staring at her inappropriate demeanor throughout this trial. So I think that statement is what pushes it over the edge from we're talking about out of court to now we're talking about very specifically she is sitting in court stone-faced. So I disagree that that's a general comment. That was something very specific, and for that reason I think it was invited.
Thank you, counsel.
thank you.
Appreciate it. Madam Clerk, if you would add 2 minutes and 40 seconds to the appellant's rebuttal time.
If I could address briefly counsel's comment about DiGiulio. I agree that this was before the harmless error standard in DiGiulio, but the court used the term reversible error to mean not just error, but an error that requires a reversal. That's what they meant. Before we had the harmless error standard and the burden on the opposing party, the appellant had the burden of showing reversible error. And the Supreme Court of Florida is describing this as reversible error, meaning there's no other way around it. And if you think about it for a minute, there couldn't be any other way around it. If you want to say that just vacating one of the convictions clears it up, then you may as well just abandon this whole remedy about compelling an election. What would the point of it be if you could fix it later? If you could take two charges, one a capital felony punishable by life without parole, and another one, and let them put them both in front of the jury, and then later on, if they get convicted of both, pick the one that they want to vacate. It doesn't make any sense. It would completely undercut the remedy. So I know these cases are old. I've conceded that. But they've not been reversed. And I think the court has an obligation. And by the way, while we're on the subject, I think that on the Bazemore case, Judge Altenburn in that case actually made a suggestion that this problem could be cured by giving the jury an instruction. In other words, if you didn't force them to make a choice, you could actually instruct the jury, these are inconsistent, you can only pick one or the other. I actually suggested that to Judge Hankinson. I would have been happy with that, because maybe the jury would have picked accessory. But he didn't do that. He sent them both back. Mr. Fuchs argued for a conviction on both, and he got a conviction on both. So I think that is, in the language of the case law from the 40s and 50s, reversible error. In the language of today, not harmless error. Let me say a thing or two about this insurance policy, the business about paying the premium on the insurance policy. This is an argument that was made about 10 times in the appellee's brief. And it is the first place where the argument was ever made. Nobody in the trial court ever thought that this was an act. I asked Investigator Devaney, the chief investigator for the state, if the defendant, quote, took any action in furtherance of the plan, if she committed any overt act to make that happen. And Investigator Devaney answered, an overt act? No, sir. When the state started out with the theory that helping or making sure that he went hunting was the act, that was what they argued at the judgment of acquittal argument. And when it became clear to them that there was actually no evidence that she did that, they said, oh, well, it's a verbal act. But here's the problem. What was the verbal act? I think you've identified this problem in your questioning. Whether we get beyond this debate about whether you need a physical act or a verbal act, there is still nothing that the defendant did or said that helps the Winchester in the actual commission of the crime.
Well, currently our standard is we're also supposed to consider all reasonable inferences from the evidence in favor of the state, and the state points out that clearly she had veto power over the first trip. So can the jury not reasonably infer that she did not undertake that veto power or affirmatively allowed him to go on their anniversary on the hunting trip?
Well, first of all, I don't know whether allowing a person to go hunting, we don't know whether he was otherwise planning to go hunting or inclined to go hunting. I don't know how that is that necessarily an act in
Well, don't we
furtherance.
have Mr. Winchester's testimony to that effect?
He testified that that was her role, and he testified on the first trip on December 9th, she stopped him from going hunting. I think the only inference you could really draw, maybe, is that she had the power to stop him. But we're really getting pretty far afield with this. First of all, to say that they're going to rely on an inference, that's pretty much a confession that they don't have any evidence, isn't it? I mean, they're relying on an inference. And I think they're asking you to make that inference do a whole lot of work, a whole lot more work than it should.
Well, counsel, how specific do you assert the words need to be? Did Winchester need to testify that, okay, to the defendant, you'll get Mike to the hunting trip? And was it necessary for him to say, and she said, okay, I will? Is that would that be enough?
I think the problem here is, you mean if there was evidence she said that on the day of or something like that?
If let's say 2 days before the murder, this is a hypothetical, Winchester said, okay, you'll get him to go duck hunting on Saturday, and she said, okay, I will make it happen.
Well, first of all, she didn't say that, but.
I understand
just to
that's
She
a
didn't say
hypothetical.
that, but just to take your example, that would be, I think, if anything, would be evidence that goes to planning the crime. Planning a crime is a crime. I'm not arguing that. Covering up a crime is a crime. I'm not arguing that. What I am arguing is that there is no evidence of assisting in the commission of this crime. And that's important. So if she told him a week before or 2 days before, yeah, I'll get that done, I don't know how that can be how you could possibly characterize that as something that she said that actually assisted him in the actual commission of the crime, because we don't know that she did that. And frankly, the inference that she did that is contrary to the direct evidence that we have in the case. The direct evidence we have in the case is that they didn't have any contact with each other. When I say they, I mean Brian and Denise didn't have any contact with each other for a couple of days before December 16th. That the trip on the 16th was planned entirely by Brian. That's in the record. He called Mike. He told Mike where to go. He told Mike where they would meet. They agreed that there's no evidence that Denise had anything whatsoever to do with that. So we're going to sit here and convict her. The state is asking you to sit here to affirm her conviction based on the fact that, well, maybe she let him go hunting that day.
Are you making a distinction between participation in planning an offense and doing something in furtherance of that plan?
Yes, I absolutely am. That's right.
And what is the basis of that distinction?
Well, I don't think you're guilty of committing a crime just because you had knowledge it was going to be committed.
Well, that's different. I mean, having knowledge of it is different.
Or that you planned it. Or that you planned it. Planning could be solicitation or conspiracy, but it's not the commission of the actual offense. I mean, I think what that could show, and what the jury was entitled to infer from that, is that she knew and that maybe she had the intent. But remember from Ammons, you have to not only have an intent, you have to actually do something that helps in the commission of the crime. And here the state doesn't have anything to show that she did or said anything in the commission of the crime. Let me just make one other comment very quickly. Brian Winchester testified that he never even told Denise that he had shot Mike. So, I mean, it's pretty hard to understand how you could say she was a principal to a crime. She never had any verification. She didn't go. She wasn't there, and never even had any verification that the crime had been committed. Thank you.
Counsel. Thank you to both attorneys for excellent presentations. The court stands adjourned.
All rise.